Okay, it says we're live, so we must be live. It is our monthly YouTube show, Work Comp Today. I'm Bernard Nomberg out of Birmingham. Got Brother David, always the ever enthusiastic participant here. Thank you, David, for showing up and showing out. How are you doing today?
That's me. Thank you. I'm doing great.
That's right. And we've got our guest out of the Atlanta area. We've got Bruce Carraway. Bruce, how's your day going today, bud?
It's going great. Glad to be here. Hope you guys are doing well.
We
Good.
are, and this is affectionately a show that David has retitled several times, but basically it's Work Comp for Nerds. So that's why the three of us get together. We each month, David and I have a guest each month, and usually it's a practitioner, somebody from different parts of the country. We get together to talk about the latest news involving employees, employers, and independent contractors. And frankly, from the news each month, there's never a shortage of things we can talk about. We typically hit some of the biggest employers in the country have news, like Amazon or the Postal Service, you name it. And then we've had lots and lots of gig economy and pandemic related news over the last 2 or 3 years. And some of these articles we're going to get into are going to be some of those, but some new topics are starting to trend up. But before we get into this month's articles, Bruce, share a little bit about yourself and your practice in Atlanta, and then we'll get going on the other stuff for the week. For the month.
Okay, sounds good, Bernard. I appreciate being here with you and David. Yeah, as you indicated, so I'm an attorney. I do practice in Atlanta, Georgia. Went to Emory Law School too many years ago, probably 1986. So that makes me 37 years as a lawyer. As far as my practice, I have done primarily representing claimants and workers' compensation claims. My office is currently in the Electrical Workers Union building, the IBEW 613 in Atlanta. So I do a fair amount of working with organized labor. I am a fan of the different campaigns going on. Delta out of Atlanta, they're trying to organize their workers into a union. I'm also on the NFL Players Association. I'm on their panel of approved workers' comp attorneys. So I represent a fair number of Atlanta Falcons and some other XFL different football leagues around. Also, I'm on the Major League Baseball panel of approved workers' comp attorneys. I've been chair of the Atlanta Bar Association, but primarily keeping my head down, just doing workers' comp. One other twist, I also handle longshore workers' comp claims. We don't have a port in Atlanta, but longshore does apply to people unloading ships, navigable water, whether it's Mississippi River, but it also applies to workers for government contractors overseas. So if you're working for Lockheed, I have some workers that work the aerostat balloons. I don't know if you've heard of balloons up in the air in wartime. So they've had some injuries doing that. So those are actually tied to a rope, but those contractors are included under longshore workers' comp also. But glad to be here.
Well, we're very glad to have you here and very impressed with all the work that you've done over the years. And in comparison, David just is very proud of the lunch he has each day. He reports that back to the firm. So you see the difference in priorities, Bruce, around that.
Fantastic. I tell you, Bruce, I'm a little jealous of your office location. That seems like a very strategic place to be located. Well done.
Yeah, thanks.
Absolutely.
It is the house of labor.
Yeah.
Well, fellas, let's get into our monthly articles, and the first one is coming out of California, and the title of it is SB 636, Utilization Review by California Doctors in Work Comp Cases. And we talked a little bit before we went on live, Bruce. Alabama's work comp system does have utilization review. I know that Georgia has its own version. We're going to kind of get into that a little bit. But Dave, I want you to kind of summarize in about 18 seconds or less about Alabama's utilization review process, how it helps the employees, injured workers, and how it harms their cases sometimes.
Yeah. So utilization review is a it is set up through the administration or administrative regulations that govern work comp in the state of Alabama. And essentially, if a doctor, the authorized treating doctor, orders, say, an MRI on an injured worker's shoulder, the work comp carrier has the right to send that request to utilization review, which means that a doctor will review the request, review medical records, and see if it is medically necessary or reasonable. And that doctor can say, yeah, it's related, and work comp will approve the MRI on the shoulder. Or that utilization review doctor, now keep in mind that utilization review doctor is only reviewing records. He's not laid hands or examined that injured worker. He could say, no, it's not related, or it's not medically necessary or needed. And work comp, based on that doctor, that utilization review doctor's opinion, can deny the MRI.
Bruce, in comparison, how do you guys handle those situations, particularly when your client is either dissatisfied with the care that he or she is getting, or I guess I should rephrase it this way. A procedure is requested by the authorized doctor, but then the insurance company may step in and say, let's pump the brakes there because we all know we want to save money here. Or they're just delaying care for no reason. How does utilization review work in Georgia to help out your clients?
Yeah, and you hit the nail on the head, Bernard. Is the delay is that's the main thing insurance companies do. They delay benefit, wage loss. They delay medical treatment. So fortunately in Georgia, we do have a fairly active bar that we have been able to get a rule in place that it's a petition for medical treatment. It's called a PMT. So if Dr. Jones wants my doctor to have a cervical fusion, then and I call the adjuster says, well, let me look at it, send me the records, and a week goes by, a month goes by, 6 months go by, they still haven't said yes or no. That's the big problem. I can file for a hearing and then 2 years later get it approved. So we do have a program in place where if you file the petition for medical treatment, the PMT, the workers' comp judge within 5 days sets up a telephone conference, and we talk about the issues of the case. The insurance company usually says we're not going to pay for it. Then we have to file for a hearing and go through the whole process. But at least it forces the issue, and sometimes lightning can strike and they can say yes, I will pay for it. But the good news is when you have a judge looking at it, and I think at some point the insurance company should be embarrassed, if this happens 10 times a week, they should get their act together and say yes or no, we're going to approve it. For the state of Georgia cases, they do have utilization review where they pick a doctor, that doctor reviews it, and 6 months later you get an answer. But that's just a nightmare.
Well, welcome to our world, Bruce. Whenever we ask these comparisons about policies or procedures and the laws, it's inevitable in most of these situations. Alabama is kind of behind the times, but don't get David started talking about utilization review. He's talked about it many days on seminars and such. All right, fellas, let's pivot. Let's move on to the next one. And this is important because we all talk to our clients and we stress to our clients the benefits of quickly reporting workers' compensation claims. Bruce, why is that important to you that they get reported as quickly as possible?
Yeah, and probably, two main reasons. I don't know about four, but, one is credibility. If you, when I've had clients that have said, look, my shoulder's been hurting me for 6 months, I didn't want to get fired. I didn't want to tell anybody. So the judge, is not going to believe it if you don't tell them right away. But there's also just collecting evidence. I mean, if you report your injury right away, then you can, your coworker may give a statement. Yeah, I saw the generator fall on his arm. It also forces the insurance company to keep their evidence. There's something called spoliation. It's a fun word to say, but there's spoliation if there's a videotape of the accident happening, but if you don't report it 6 months later, well, we never heard about it, so we destroyed the videotape. But if you report it and they destroy the videotape, then it's assumed that the accident happened and that they're hiding something. So there's a big advantage in reporting the accident right away.
Dave, is there anything you can supplement? Because Bruce said it well there.
Yeah, he hit the nail on the head. What I was thinking about why the employee needs to provide prompt notice of an accident is that they can get prompt treatment. I mean, that's what work comp, one of the tenets of work comp is. It's designed to provide prompt medical treatment to the injured worker. So prompt medical treatment leads to hopefully a quicker recovery, puts the injured worker back to work more quickly, and they start earning a paycheck again, and that's good for their wallet.
The worst, Bruce, is when, and you've had this, I think all of us have this, somebody calls 10 days before the statute of limitations. They haven't had an attorney because the company's going to take care of them. And things just get delayed. And it always is so much better for everything to happen on the early end of things, particularly the reporting, so you can do exactly what you two fellas have just suggested.
Correct. And there are time deadlines. So in Georgia, we do have 30 days. If you wait 31 days to report it, you might lose for that reason. There is a time deadline of 30 days to report it.
We've got what, 5 days orally, 90 days in writing.
Yeah.
It's just, I don't know how they came up with this back in the day, but anyway, a lot of cases go on notice. That's absolutely right. Well, fellas, the next article, actually, we're going to combine a second article that Bruce offered, but we're talking about the Philadelphia Eagles, the second place Super Bowl recipient or finisher this year. The first one is the Eagles lose an appeal in a work comp case. And then the article that Bruce had found is that the former captain of their team wins a huge verdict over doctors on a career-ending knee injury. And Bruce, with your experience representing NFL players in work comp cases, let's step back a little bit from these two articles and just talk in general how pro athletes, particularly NFL athletes, it's a little bit different game than it is just the construction worker or our typical client situation who gets hurt.
Yes, it is. And I've got the perspective also. My son played in the minor league system for the Mariners for 5 years. So I've got a little taste of the tough life of an athlete. Everybody thinks that, they're living high on the hog and this is all glory. And, it's just the incredible amount of work that goes into, to making a college team and then an NFL team. So there is the dynamic of, I put this much work into it and I've sprained my ankle, I'm going to keep playing. We saw that in the Super Bowl. Patrick Mahomes play, he was a superstar because he's playing on a sprained ankle. Of course, when he's my age, he won't be able to walk because he, didn't get medical care for that. But that is the dynamic of, so the workers' comp case that we've cited, we're talking about in general, the guy that hurt his thumb, there was a delay in his getting full treatment, and I think if you look at the time frame on it, he got hurt in 2015, and then the final ruling came out, this month, February 3rd, 2023. So 8 years later, before he finally got a ruling that he was owed partial wage loss benefits. But, football players, a lot of them are, if you're, Patrick Mahomes and you have a $200 million contract, workers' comp might not matter that much. But a lot of these guys, if you're a practice squad player, if you're, a journeyman come in and play 2 games, or even a year, workers' comp makes a big difference.
Yeah.
So I think in the other Eagles case where he had a thumb injury and he was able to get, 3 years of wage loss, partial wage loss, it made a difference at that time. But I do want to talk about the malpractice case. And to me, I did talk to a sports agent this week. He was the one that kind of tipped me off to it. He said, "Hey, did you hear about this? What's the guy's name? Margolis case." It's like, what do you think? And he's like, well, he thought it was terrible because he thought, well, if doctors are sued for malpractice on how they handle workers' comp cases, they won't handle workers' comp cases anymore. And that's a problem. That's a separate podcast you can do. But from my perspective, whether it's a football player, in this situation, apparently he had a knee injury, had PCL surgery. They missed his torn meniscus. They put him back into physical therapy too quickly, or I'm sorry, they said, yeah, you're good to play too quickly. So he played on it, basically progressed too quickly and then was damaged so much that he could never play again. But to me, this is all too common, that whether you're an Atlanta Falcon, a Buccaneer, whatever, or if you're working in a chicken plant, same deal. I have a lot of chicken plant workers that they have carpal tunnel surgery, Tyson Foods. I mean, they'll do carpal tunnel surgery and they will put them back on the line doing chickens that same day. And how does that possibly go on? How can a doctor possibly say it's okay to use a knife on chicken the day that I used a knife on you to do carpal tunnel surgery?
Yeah.
So, us as practitioners, we probably do need to look more into, if your guy has back surgery and he's back doing regular duty, whatever, there might be a malpractice case in there. And we did, myself and my partner at the time, David Moskowitz, we did bring a corporate malpractice case against Tyson Foods because they were running a company clinic. The company clinic was basically like I'm talking about. They were putting ice on people's carpal tunnel, not sending them to a doctor, saving a lot of money because in-house physical therapy. So ended up having a big settlement against Tyson's because they were practicing medicine without a license. So to me, I think it's great. I think good for the Eagles player, the special teams guy, to get this big verdict. Maybe it'll open up doctors' eyes that, if the company nurse, the plant manager, even the player, I want to get back out there, do your job, tell them to know, go slow, do physical therapy, take time off work, get healed up, then go back.
Bruce, I want to ask Bruce about that because I've seen that too, Bruce, where, you 30 days after back surgery, back to work, or your example about Tyson, within a day, you're back on the line. Is that coming from the pressure from the case nurse pressuring the doctor? Is it someone lying to the doctor and saying, oh, they're going to be on light duty, we got a spot for them? Why would a doctor allow a patient who still literally has anesthesia in their body operate a sharp instrument, at work within 24 hours of surgery?
Well, unfortunately, it's money. Everybody wants more referrals. So I'm guessing that, when Tyson is spending, 30 people a year to this doctor for surgery or more, and then the nurse comes to meet with them and, can't she go back full duty now? And, if you do that, you'll make us happy. If you don't do it, we're not happy. It's just the politics of, I guess it's the way they get money. It is the nurse case manager. Like I say, that's like a whole nother conversation, but they are putting words in the doctor's mouth.
The answer is money. What's the question?
Don't forget, don't leave out of this equation the influence, the impact of the adjuster in trying to basically practice medicine without that license. We've all thought that at different times of our cases. But going back to the doctor part of the equation, Bruce, with the NFL, remember the somewhat ridiculous movie Any Given Sunday, the James Woods character who was the longtime Dolphins in-house orthopedic, and he runs into the younger doctor, Matthew Modine, that conflict between one has already sold his soul to the devil and the other one is trying to prevent his soul from being taken. But it's that, I'm sure it happens every day with those doctors. Look at the injuries to Tua this past year and all of the highlight of them. But you're right, this could be a whole nother topic for a whole nother day. So we need to probably pause that one. And for those of you just tuning in or seeing us on our replay later on, we have Atlanta attorney Bruce Carraway is our guest. Bruce does NFL work comp. He does longshore cases. He does work comp. He does a whole lot of stuff in the state of Georgia, and we're glad to have him with us today on our monthly Work Comp Today show. And we're plowing through our articles. We're up to the next article, fellas. And the name of it, this comes out of New Hampshire, and this will be a bigger ticket topic for us. Bill would expand workers' comp cancer presumption for New Hampshire firefighters. And David, you know, my question is going to come to you and say, how does Alabama deal with this issue?
We don't. Although there is a recent passing of a law for firefighters dealing with heart attacks, I believe, but it's not covered under the Work Comp Act. It's outside the Work Comp Act. Let Bruce probably take this one too, but I do have a comment to make after Bruce addresses it.
Go ahead, Bruce. How does Georgia deal with this issue?
Well, I'll copy David on that. You know, pretty much we don't. It's, you know, there was a bill recent, I think I want to say 2019, that the legislature did pass, you know, trying to give more present. The problem is, you know, firefighters are exposed to a lot of smoke, you know, a lot of, you know, all kind of bad chemicals. You know, I think there's, you know, even flame retardant stuff puts off, you know, cancer causing chemicals. So it's, you know, so it's kind of common sense, you know, it's right there with smoking cigarettes and then you get cancer. Well, did it come from cigarettes? Well, we can't prove that, you know, 51% sure, you know, so you need a presumption to be able to get you over the goal line to say, yes, you know, if you get cancer, it probably came from work, you know, and with firefighters, you know, it's probably more likely they're going to get it than other workers. You know, of course, I don't, you know, steel workers, you know, there's a lot of other, you know, if you're doing roofing tar, it's probably not very good for you either. Anyway, but Georgia, you know, did pass a law stating that, yeah, this presumption will apply to firefighters. Doesn't apply to everybody else, but, you know, everybody likes firefighters. Let's give them a bone. And Governor Nathan Deal said, no, you know, I'm not gonna do that. You know, the insurance lobby has contacted me and they don't want to pay for it. So so he vetoed it. You know, so they did pass a law that instead of your widow getting lifetime benefits, instead of your widow, you know, actually getting a living wage for the next 20 years, your widow will get 3 years of, you know, some type of benefits. You know, so it's more of a disability policy, you know, that if you get cancer, we'll give you these, you know, limited benefits. You know, we won't necessarily pay for your treatment, but your widow will get 3 years of benefits. So it's just really, really watered down where it's nothing. And I do, you know, I had a client I talked to this morning that, you know, with my longshore practice, you know, he was over in Afghanistan and he said, look, you know, I'm having these breathing problems. And I think it probably came from the burn pits I was exposed to. You know, I think that, you know, that President Biden's son, you know, I think he died of cancer and they thought maybe it came from the burn pits. You know, you can't prove it. But, you know, so it's similar with firefighters. So I think it's a law that should pass. And I think legally, you know, if it's a presumption that it came from that, you know, that gets you over the goal line, you know, it's just presumed. But then if they come in and say, well, wait a minute, you know, we see here where he was, you know, smoking crack and smoking 3 packs of cigarettes and it came from something else, they can still rebut that presumption. But the problem is it's just cancer is something where it's hard to prove 51% sure where it came from. So there needs to be a remedy of that presumption.
I wanted to just take this time based on this article to plug an organization we're members of, WILG, which is the Workers' Injury Law Advocacy Group, which is made up of about 1,100 lawyers from around the country who represent injured workers who are claimants lawyers like us. And the reason I bring it up now is WILG just started a firefighters cancer task force that is co-chaired by our friends Anne-Marie Pentazis out of North Carolina, who's been a guest before, and Jeff Bickler out of Florida. They're doing a great job on this brand new task force and bringing awareness concerning cancer exposure, cancer diagnoses in firefighters. And they are there's a lot of recent research on cancer. These carcinogens that are in these products, like you mentioned, Bruce, and the flame retardant stuff they're using. So they're doing some really good stuff for firefighters. So just want to mention that.
Well, thank you, Dave. We usually try to mention the organization at least once or twice with each of our shows because most of our guests are fellow members of the organization.
Yep.
Fellas, let's keep moving forward. It's inevitable. We've got a fraud case here. Louisiana doctor sentenced to 4 years in prison, ordered to pay more than $800,000 to victims in work comp fraud conspiracy. David, I know you love a good conspiracy case. Share with us a little bit about this bad boy.
Yeah, so this was a 61-year-old doctor out of Alexandria, Louisiana, sentenced to 4 years in prison. And as you said, he's got to pay $800,000 back to the victims. From what I can tell, he was, I guess, a pain doctor, and he was prescribing and also filling pain creams and patches to work comp patients. And he was doing, part of the scheme was he was filling it in his own pharmacy. And I know that that is a big problem in the work comp industry. The work comp carriers who are paying these bills, they don't like doctors dispensing medicine out of their own pharmacy because they can't control the pricing. And then, of course, you've got self-dealing. And here, this doctor was part of a big scheme, and he's splitting the profits and kicking back money. And there is big work comp is big business. It is big money, especially on the employer side, the work comp industry side, or the work comp carrier side, as well as doctors. There's a whole lot of people in this work comp industrial complex, and there's a lot of money to be made. And unfortunately, you got some less than honest people like this doctor, and he's going to jail.
Bruce, did you see in there where almost $1.5 million in losses were accumulated in 4 years? Unbelievable, this scheme that they came up with, and it just took them that much money was at issue in just 4 years time period.
Yeah, we talk about, this at least once a year about fraud and work comp. And I know that employees are guilty of fraud, but the sheer amount of money when it comes to fraud is on the business and work comp insurance side of it. The sheer volume of the money when fraud is committed is on the employer work comp side.
Bruce, we've had situations in Alabama where employers underreport the amount of compensation they pay, which impacts the premiums they pay. We've had doctors similar to this Louisiana doctor where they've created this fraudulent scheme. And then we've had injured workers who have taken advantage of the system where they're still working in some other job that they're not reporting, but yet they're claiming they can't work and they get all of this workers' comp. So that's just three quick examples, as David was referring to. Can you think of any other situations that you've heard about where someone has ultimately created some kind of a scheme and then they get busted for it in the work comp system?
I haven't, and before I get to that, I mean, I will just state that usually, it's Geraldo Rivera, caught somebody working when they were drawing workers' comp. That's usually you tell somebody at a cocktail party you're a lawyer, and they're, you represent those people that are pretending like they're hurt.
That's right.
It happens, maybe once in 36 years, I've seen a video of my client doing something they shouldn't, but you're correct, Bernard. I mean, usually it is, underreporting payroll, not, or the worker, they get paid 2/3 of their payroll. So they don't include, tips, they don't include overtime. The adjuster doesn't approve medical quick enough, or doesn't file the form, or just controverts because they can. So I think fraud's a two-way street. So I'm okay, if they catch somebody committing fraud, put them in jail. I mean, there's so many people that are hurt by fraud on both sides that, go ahead and be tough about it. I'm okay with that. I will say in Georgia, we had, won't state his name, but had a pretty prominent workers' comp attorney. He was active in the trial bar and, was well respected. But I think his lifestyle got beyond him, and he was, had a personal airplane and somebody driving his car, and got where he just couldn't keep up with his, airplanes and wives. And so he dipped into his client Medicare set aside fund. So, they'd set aside, here's $400,000 for this person's lifetime medical treatment. He told him, I'll handle this for you. And then he ended up taking the money from it. So that, he got caught and he went to jail, for I think about 8 years. I think he's finally out.
As he should have been, as he should have been. Well, here's the fourth area. Here's a new area where there's the potential for problems, for fraud, for whatever you want to call it, fellas. It's our last article of the month. In a world where millions work from home, what does it mean to be injured on the job? And Bruce, this has been a hot topic for David. He has spoken about this issue half a dozen times this past year.
Yeah.
Dave, what are the typical examples of the few cases that are reported out there? What's usually involved for somebody to be legitimately injured on the job?
Yeah. I've researched and found about 10 cases nationwide over the last 20 or so years where people have been hurt at home, and it's a reported case, an appellate decision. And I think there's 3 common types of accidents in dealing with when you get hurt at home. And we've seen tripping over the family pet, falling downstairs, and then ice in the driveway. Those are about 6 of the cases I've looked at, and 6 out of 10 dealing with tripping over family pet, falling downstairs, and ice in the driveway.
It's interesting in this article, Bruce, one of our friends, you may know him as well, Alan Pierce out of Massachusetts, is quoted in this article about, he even had a case involving a coach for a high school tennis team in Massachusetts. And part of his responsibilities was telephoning results to the newspapers, etc. And what was he went home, he had dinner, walked downstairs to his home office with the intent of reporting the results, as he was part of his responsibilities. He was going down the stairs, his equipment bag caught on the shelf. He fell down and injured his knee. And as simple as that sounds, potentially that's a compensable matter. Bruce, have you had any during the last, particularly 3 or 4 years with the pandemic, 3 years, but even before that, where you've had workers at home who get injured while doing their job at home, and it's been a compensable case?
Trying to think, I don't think I have. I mean, I think I would analyze it. I mean, there is this doctrine of, some people are 24-hour employees. Once again, you get with the Defense Space Act, people, if you're in Iraq working for a contractor, whatever you're doing, you're covered under workers' comp. Even if you're at the gym playing basketball to stay in shape and you get hurt, that's covered. So, I guess I would analyze it the same way. If I've got 2 paralegals and they both work at home now. But I'm assuming, hopefully they're on the clock, from 9 to 5. But, so even if they were at work and they were taking a restroom break and they slip and fall, going to the restroom, that'd be covered under workers' comp, so I would argue, if you're on the clock, if you're working, it should be covered. It does get tricky. We also have the idea of idiopathic injuries. I don't know if that's a hot topic in Alabama like it is in Georgia.
Yeah.
But, in Georgia, the whole idea is like there was a school teacher that was walking across the room, and as she walked, her knee gave out, and the court said, well, her knee could have given out if she was at home or if she was at work. So she's not entitled to benefits because it was nothing specific to work. So it gets kind of tangled up if you're at home and your cat runs in front of you and you fall over. I fell because I was getting up to get a paperclip. I was working, but they're going to say you fell because of the cat. So, but I would still argue that if you're working, you ought to be covered no matter what you're doing.
These cases are so fact specific, as most work comp cases are, but typically, David, with your research, have you typically found that there are no witnesses to the events?
Yes. Generally, there is not a witness. you've got the increased potential for being caught on camera because of the increase in Ring or Nest doorbell cams. There's been one or two cases I can think of where the injured worker was assaulted, so that person that would be a witness. But yeah, for the most part, there's not a witness, there's not coworkers around, there's not surveillance cameras up like we see in so many warehouse, factory, hospital settings.
Mhm.
So most of the time it is generally just the injured worker's testimony. There's nobody else to.
Maybe the corroborating medical records if they went to an ER or something like that. But those are just like in our regular brick and mortar work comp cases. All of that's got to line up for the credibility to be to be intact. But this article and this topic are going nowhere, meaning they're not leaving us anytime soon. We're going to have more of these in the upcoming months and years with more and more people working remotely or from home. Well, fellas, go ahead.
Hang on. I know you mentioned that Alan Pierce was quoted in this article, but I did want to identify him as past Willig President Alan Pierce.
Thank you.
Yeah.
Thank you.
And a top-notch work comp lawyer. And of course, his son, Judd, works with him. Judd's been a guest on this program.
He has.
in
And
the
other
past.
than being Boston Red Sox fans, those are some fantastic fellas. That's for sure.
Yeah, we're fans.
Besides
of
that,
That's right. Well, guys, we've got Bruce Carraway out of Atlanta as our guest this week or this month on Work Comp Today. We've flown through the articles for this episode, but we've got a couple of topics as we get toward the end of our show. We like to compare. Well, I say we tolerate because Alabama's always on the lower end of the comparison. We want to compare a few policies, procedures, laws about how things are done in Georgia with work comp as opposed to how things are done in Alabama. We've already covered the first one, that was utilization review. So we're going to move to the next topic, which we're going to talk about, Bruce, what kind of damages, just in general, that an injured worker may be entitled to when they are injured on the job in Georgia.
sure. And in Georgia, probably in most states, unfortunately, you cannot get pain and suffering from a workers' comp injury. It really creates, some heartache of people that, I have clients that have lost their leg. What would you take for losing your leg? And, so to walk through that example, basically, if someone loses their leg, then they're first of all entitled to temporary total disability benefits. If they're totally out of work, they get 2/3 of their pay. And in Georgia, it's been creeping up. When I first started, workers were getting $175 a week. Unfortunately, if someone got hurt back in 1986, and I talked to a guy that worked for the GBI that was still getting $175 a week for his injury in 1990, there's not a cost of living adjustment like there should be. Anyway, so that when you're totally out in Georgia, it's currently $725. I think there is a bill going through the Georgia House and Senate that should be signed off. That's going up to $800. One thing in Georgia, you can only get 400 weeks of benefits. So after you get 7 years of workers' comp benefits, even if your leg's been cut off, if you can do some kind of work, they cut off your benefits. Second benefit you get is temporary partial. That's if you were making $1,000 a week, now you're making $700, you're losing $300 a week. You can still collect 2/3 of what you're losing. And so I strongly encourage my clients, if you get hurt, go work, go, especially if you're making good money before, and now the best you can do is, you're losing $600, well, you can get, $400 a week. Currently it's $483 a week. It's going up to $533. So the good news is, you can work part-time and still, if you're getting $500 a week in wage loss, that's $25,000. So they might have to pay you, $125,000 over 5 years' time while you're working, because not working is poison. If you're totally out of work, you lose your leg and you sit home every day. A lot of those folks are needing psychological treatment, and they're entitled to it. The third benefit is is permanent partial disability. You know, a leg in Georgia is worth 225 weeks. So that means that if your leg is totally cut off and your workers' comp rate is $300 a week, then you get 300 times 225, and you get about $65,000 for your leg. You know, my legs are worth at least 200,000, but in Georgia, you know, if my comp rate was 300, you know, it would be $65,000. I understand in Alabama it's even lower. So, but
Yes, it
the
is.
fourth benefit you get is medical treatment. You know, there is, and that's medical is one thing that, you know, that, you know, it's better than Medicare. It's better than some health insurance. They pay 100%. You know, if your doctor orders it, they're supposed to pay for it. If your doctor refers you to another doctor, they're supposed to pay for it. There is a list of doctors, a panel of physicians where you know, the company gets to pick your doctor. So that can create a problem. You know, that's where politics come in. And, you know, well, I know you've had back surgery and your back's killing you and you can't sleep, but I'm not going to order a mattress for you because the insurance company will, you know, they won't send me more work. But so that's the four main benefits in Georgia. There's temporary total when you're totally out, temporary partial when you're partially out, you know, the damage to your body, and then medical treatment. You know, one other important issue in Georgia, there is a cap where you're only entitled to wage loss and medical treatment for a maximum of 400 weeks. So, you know, I've had football players that, you know, you hurt your back and, you know, 10 years later, you've got to have a fusion and have all this treatment done so you can walk. Workers' comp won't have to pay for it. You know, to me, that's theft, you know, but there is a one way around it. If the case is deemed catastrophic, if you qualify as basically you can't do any kind of work at all, the Social Security definition of, you know, there's no work within your geographic area that, you know, you can do substantial gainful employment, you know, then you're catastrophic, you know, then you can get lifetime income benefits, lifetime medical treatment. But that's a high bar to prove. You know, if you can work, you know, taking tickets at a movie theater, at a parking garage, you're not catastrophic, you're not getting those benefits.
So, Bruce,
That's where we are with Georgia.
It's so different from our system. Dave, you want to kind of hit the highlights or the lowlights without getting too depressed?
Yeah, I'll start with what the injured worker cannot receive under the Alabama Workers' Compensation Act. So there's no money paid for pain and suffering, emotional distress, mental anguish, or lost wages, and their spouse cannot get any money for a loss of consortium. So those things are not allowed either at settlement or at trial. If an employee is hurt, then they get three benefits out of the gate. Okay, number one, of course, is medical treatment. Number two is reimbursement on mileage when they go to the doctor, the pharmacist, or physical therapist. And then three, if the authorized doctor takes them off of work, then they would get temporary total disability benefits starting on the fourth day. At the conclusion of their treatment, or once they reach maximum medical improvement, or MMI, the injured worker, if they have a permanent physical impairment or permanent work restrictions and they can't go back to work at a job paying a similar rate, then they may be entitled to compensation for that. And of course, if we try the case, then the judge can determine what the impairment rating is or what the vocational disability is. And of course, at trial, you're trying to get either permanent partial disability, which is capped at $66,000, or permanent and total disability, which is a lifetime medical benefit, and it's two-thirds of the average weekly wage, which is their comp rate, and they can get that for life so long as they're living, but they can't return to work, and they could get lifetime medical care, Bruce. So we have to do a little distinction there. We don't have a cap on medical benefits. It's a lifetime benefit.
But Bruce, here's what's really depressing. David, how old were you the last time the rates in Alabama were changed?
I was 12 years old, so I was in sixth grade, maybe.
Bruce, that was 1987.
Holy cow.
The rates have not changed. Can you believe that?
What is the maximum rate that you can get?
On PPD, it's $220 a week. And in 1987, that was a living wage. It was higher than the poverty level. You could support a family of 4. Now it's below the poverty level. It's below minimum wage.
Way below both.
Yeah.
Well, on that
Yeah,
depressing
that's
note,
and is that for wage loss? I mean, because for Georgia, PPD means you lose your hand, you get permanent partial disability.
Yeah.
That's where you get the different terminology.
Yeah, that's not-
Bruce. It's to cover either a scheduled injury or less than 99% or lower. Okay, it just means you're not 100% disabled.
Okay.
It's capped at $220 a week for 300 weeks, with the carrier getting a credit for TTD paid.
But so that's what you would have to live on if you're disabled, is the $220 a week?
Yes, sir.
Yep.
Yes, sir.
Wow.
Feel better about yourself, Bruce. Now let's move on to the last
I
thing,
still
guys.
don't.
We got about.
So
3
I will
minutes
throw
left.
out there, not to bring religion and politics into it. I did just finish reading the Old Testament. It took me about 3 years, and I can't even. It's kind of like a case. I remember the situation, but not the chapter and verse. But there's a lot of verses in the Bible. In the Old Testament, one of the final things they talk about is pay your workers. If someone works for you, do not cheat your workers. Pay them their salary. If you don't, that's a sin. So that's what's going on here. In Alabama and Georgia also. Somebody works, they get hurt, they can't work. When the law was set up, it was meant to compensate them for their wages. So this wage theft that's gone on in Alabama and Georgia, it's wrong. I mean, that's my opinion.
Oh, it's our opinion, obviously, very much so. Bruce, final topic. In Alabama, we can conclude a workers' compensation case with a trial in front of a judge, not a jury, but a circuit level court judge in state court. We may be the only state, David, I think, that does our trials that way. There's no tribunals, there's no panels, there's no administrative law system. We're in circuit court. How does Georgia conclude through trials or hearings its workers' comp cases?
And Georgia, I mean, you have a right to a bench trial in front of an administrative law judge. And believe me, I have a lot of clients that, I want a jury trial. I want to jury my peers to have my day in court and prove my case, and no politics. Let's just see what the common man says, and we don't get that. So you do get a bench trial with the workers' comp judge. The good news is the workers' comp judge, most usually they're a lawyer, hopefully they've had some experience with workers' comp, and that's all they do is hear workers' comp cases. So, so they're pretty tuned in to, get to the point, enough of this drama, about, your boss didn't like you, you don't like your boss, but,
right.
Let's talk about your work limits and, can you work anywhere?
Yeah.
So the good news is the State Board of Workers' Comp has probably 20 judges that work for them. That's how when medical's not approved, you get a judge on the phone in 5 days and they tell you if it should be approved or not. That's great. I will say there is this idea of, administrative capture, we're trying to think of the technical term, but, at some point the judges, they're appointed by the governor. Our governor, is a Republican. He's there for big business, and so the judges are working for the governor. So there could be some politics that come into it, where sometimes maybe having a random circuit judge might be better. But all in all, I think our judges are professional. It's a good system. And we do have so you try the case before the administrative law judge, and then if you lose, it goes before the chairman of the workers' comp board and two other judges, the appellate division. If you want to appeal from there, you go to Superior Court, from Superior Court of Appeals, and then the Supreme Court. So it can be a long system, and until you went all the way up, they don't have to pay. So, they could starve you out for 1 or 2 years, on a case that's totally valid, and try and force a low settlement.
Bruce, one of the other distinctions is our judges in circuit court are the same judges who hear domestic relations, If they're in the certain counties, they could hear criminal, they could hear civil. So our judges are not specifically trained, only if their practices included work comp, do they bring that to the table, so to speak. And David, I would say in our entire state, there's probably not a dozen lawyers who have legitimate, decent work comp practice experience before going on to the being a judge. So Bruce, we have a lot of education through our cases. So
some dabbled in it and some avoided it altogether, but yeah, very few were experienced work comp practitioners when at the time they joined the bench.
Well, Bruce, we don't want to end our monthly episode on such a depressing note. So take this with you. You got to spend a quality 50 minutes with David and Bernard today talking about work comp matters. So there you go.
I appreciate the opportunity, and I think it's good we can I think both of our systems could use some change, some justice. Part of it's the slow system. It sounds like our system could take 2 years. I don't know how long does it take with your system from you get hurt, you file for a hearing, and before you get a final judgment, the worker's paid.
It could take a year or two or more. They're all slow systems. They're all meant to be slow for various reasons. But Dave, I want to thank you again for surviving, thriving, and contributing to another lively episode of Work Comp Today. So thank you, bud.
It's my pleasure, and you all are welcome.
And Bruce, that's usually we give David the final word on each episode, but we're going to change it up. We're going to offer to you, if you have anything in closing you'd like to say. We sure appreciate you spending some time and sharing your wisdom and your experience with us today. So thank you, sir.
Well, thanks, and it has been a joy to be on with you guys. I appreciate the opportunity. I will say that it is political. It is basically the legislature that's making workers' comp rules. Maybe that'll create the State Board of Workers' Comp in Alabama. So it's important to pay attention to who your legislatures are. Go talk to them at their office. Let them know workers' comp's important. But the battle goes on.
It does. And I know you're fighting the good fight, as we do here in our state as well. So thank you, Bruce. Guys, this will conclude us for our monthly episode of Work Comp Today. Usually the third or fourth Thursday of each month, we try to have a friend, a fellow practitioner from somewhere in the country to join us, as we've got attorney Bruce Carraway out of Atlanta today. You guys be well. We'll see you sometime late next month. Take care.
Thanks, guys.